Well, joining us now for another round of Ag in the Courtroom is Roger McEowen, who is a ag law professor and tax specialist at the Washburn University, the Farm Bureau ag law specialist there at the Washburn School of Law. Dr. McEowen, I think the topic that we're going to talk about is one that probably is being discussed around a lot of dinner tables as this time of the year. A lot of folks think about, okay, moving on to the next year. Is this the year we do a generational change, or do we have an event happen that we need to change some things on the farm? And you did a kind of a case study or looked at something that has implications that happened right here in Kansas.
Yeah, it was a recent opinion of the Kansas Court of Appeals just a few days ago, Ken, and it really is an eye-opener, I think, at least I hope, for a lot of people that might read the article on my blog that I wrote and posted just shortly after the opinion came out. And it really, I think, kind of highlights the issue that faces a lot of farm families, and that is you've got the surviving spouse that remains and now has passed away. So the second of mom and dad to die has now died. And the estate plan at that point in time really kicks in. And it was the classic situation where mom, who is the surviving spouse, has 5 children, and only one is going to be the farmer. And the others are not to get the farm ground or the cattle or the machine or equipment. But what she did was rather interesting, and draft estate plans that work with clients and work with farm ranch clients to be careful in what we do, that we want to make sure that clients understand what the language is that's placed in a trust. If the client wants a trust and we create a trust for a client, then make sure that that really is what the client wants, because there's a lot of information that's out there, and clients can go to various seminars. They might be put up at a hotel and they'll get a mailer on it and say, well, here's a trust seminar. If you're thinking about generational planning, come see us. And what it is are groups that specifically promote trust. So the clients think this is a good idea and they tell the attorney, I need a trust, and the attorney may not question that and not really dig deeper. And so, okay, I can create a trust for you, and there you go. Just pull it off the shelf. And the client really doesn't understand how it works. I even saw one early in my practice career in North Platte, Nebraska, where the client had gone to, a rather substantial client of the firm, had gone to one of these trust seminars at a local hotel and came in, and he was real proud. He had this 3-ring binder. It was leather, had his name emblazoned in gold on the lower right-hand corner. And the lead partner in the firm, who was recognized nationally for his work with farmers and ranchers on estate planning, and I worked directly under him, was his long-term client. And as soon as the client left, the lead attorney came up to me and said, here, take this. He paid several thousands of dollars, and this was 30 years ago, for this trust, and there's nothing in it. Nothing was funded. There was never any property transferred to the trust. So that told me, and by the way, he said, you can't bill for this, which was a bit irritating, but we had to do that for the client to clean up a mess that somebody else had created. But the client didn't understand what that document did or wouldn't do for him. He didn't question. He got a boilerplate trust. I basically had to redo the whole thing. Well, that kind of came back in my memory reading this case of last Friday, which turned out to be an absolute family disaster, and still is. It's going to go back to the trial court on remand to figure out the damages. But it points out to me that we have to be real careful. We can't just pull stuff off the shelf, get the client to sign it. We're done. You got to trust. Well, no, we've got to dig deeper into the facts. We've got to make sure the client that's the most appropriate thing for the client. Then make sure whatever we do, that the client has a general understanding of how it works, and that comports with their wishes. And that's the practice, and that's the counseling part of practice that we want to make sure that we don't skip out on.
We're talking with Dr. Roger McEowen from the Washburn School of Law. Let's take a break. We'll talk more about this interesting topic in just a moment.